The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. We are here this afternoon for the submission of 3 cases. 2 of them will be with oral argument. The first case of State versus Erica Westvangen is hereby submitted without oral argument. The first oral argument of the afternoon is Beverage versus ALCOA, and I want to do a real quick sound check with Justice Oxley, who is participating remotely today. Justice Oxley, can you hear me?
I can, thank you.
Thank you. And it's my understanding Lisa Shirley will be arguing today. If you wouldn't mind doing a really quick sound check with Justice Oxley, and then you can get going.
Yes, hello, my name is Lisa.
Thank you, Counsel.
Thank you. Good afternoon. May it please the court. My name is Lisa Shirley. I represent the family of decedent Charles Beverage. The court is being asked to interpret Iowa Code Section 686B.7. We believe the statute is ambiguous and that the tools of statutory construction should be used to determine its meaning. Ultimately, the provision should be interpreted to permit the Beverage's claims against ALCOA and against Taylor Insulation. First, the statute is ambiguous. There is little question that reasonable minds can disagree about its meaning. The parties, the lower courts in this case, and the district courts in other cases have all said that it means something different. There are at least 4 competing interpretations of what the statute means. First, in its papers, ALCOA has submitted that the statute narrows claims to manufacturers and sellers of asbestos products. The lower courts in this case said, no, only product manufacturers are going to retain liability. There's another case on appeal before this court called Fankhauser. In that case, the district court found that product manufacturers are actually immune from suit, and that the only parties that are still liable in Iowa are miners of asbestos fibers who took the fibers out of the ground, which would limit that to 1 defendant left in the United States. Our interpretation is that all defendants remain potentially liable, even under this statute, and that its meaning is that it provides a defense to product manufacturers in the form of the bare metal defense. Given this ambiguity and the competing interpretations that have been advanced for the statute, we submit that the tools of statutory construction are going to be important to determine the meaning of the statute. The tools that support our interpretation include reading the statute as a whole, considering the same laws, looking at the consequences of the particular interpretation that the lower courts used in the case, and also looking at the purpose of this statute.
All that specifically links this amendment to the bare metal defense. I mean, number one, the bare metal defense was out in the case law. It's percolating around. We know that. We know that there's language in the statute, that talks about third parties, which, maybe suggests bare metal defense. But do you have anything beyond that that would demonstrate that when the term defendants was used, it was meant in a narrow sense?
There is not any legislative history that we can rely on or any statements of intent. It's difficult to really gain a lot of meaning from where it's placed in the statute. I can talk about that a little bit, but it's not a statute that has anything to do really with defenses other than in non-malignant cases. The statute is mostly applying a requirement that people with asbestosis, which is a non-malignant disease, show physical impairment before they can proceed with their claims.
Counsel.
If I could just raise, go ahead, Justice Ox.
Just real quick. Does the reference to component part made or sold by a third party, does that itself reference a very specific defense within products liability law?
Yes, Your Honor, it really does, especially in the context of asbestos litigation in particular, because that is a common, it's kind of a scenario unique to asbestos litigation, that a defendant will sell a product that is then used with an asbestos product made by someone else.
Yeah, well, and counsel, isn't it, I mean, the doctrine itself is actually broader than asbestos. I think the bare metal defense is specific to asbestos, but the doctrine itself is kind of widely within products liability. Is that a proper understanding of that doctrine?
You know, honestly, I am only familiar with it in the context of asbestos litigation. It's certainly, it has occurred, you're right. There are situations where two products are used together in other contexts, and there will be there'll be litigation about the various liabilities, and usually there's a foreseeability analysis applied in those kinds of situations. If a company could foresee that their product would be used in a dangerous manner with another product, that sort of thing. And what the bare metal defense does is basically say, no, we're not going to use a foreseeability analysis. We're going to narrow that liability. And the DeVries case, which is cited in our papers by the U.S. Supreme Court, it does a really nice job of explaining the various approaches that have been taken to this problem in asbestos, but it would basically apply to other products as well. Like I said, when there's two used together.
So, counsel, are you familiar then with Iowa Code 613.18? Is that's kind of an attempt by, or that's the Iowa legislature's attempt to, in some circumstances at least, codify at least part of the component parts defense. How does that statute play into the analysis here?
That's a great question, Your Honor. I am familiar with the statute, and I think that statute is actually an example of what the legislature does when it intends to, eliminate certain causes of action for a seller or a non-manufacturer. That statute says that non-manufacturers do not have liability for design defect, strict liability design defect, or breach of warranty claims. And there's quite a bit of detail explaining how that defense, how that immunity would operate.
Well, on the threshold question whether this is ambiguous, I mean, we've had a number of lines of cases where courts all over the country disagreed, and yet our court found the language unambiguous. A pollution exclusion line of cases, for example. So just because the parties disagree, I don't think that gets you there, isn't? But if we do get there and apply the purpose canon, what was the purpose of this legislation?
Honor, would you like me to address the ambiguity issue? Okay. Yeah, so I think the case law does indicate that disagreement, if there are multiple reasonable meanings that could be gleaned from the language, that in itself is an indication that it's ambiguous. And as I was indicating, there are actually at least 4 different interpretations that could be gained from this one sentence. So, that's the main thing I think that makes it ambiguous. The language is, I mean, I think, admittedly, it's kind of strange language. I mean, talking about products made by a third party is not the ordinary way that immunity statutes are phrased. And the statute we were just discussing about the non-manufacturers, that I think is a good example of how this would ordinarily be framed by the legislature in terms of identifying non-manufacturers, retailers, companies of that nature. But to get to your second part of your question, can you remind me what that was?
What's the purpose of this legislation?
To the extent that there is purpose, I think it's a little unclear because of the way it appears as the final line in a statute about procedures mostly governing non-malignant cases. I think the through line with some of the other provisions is that in in particular the asbestos bankruptcy trust provisions, is that the legislature does not want companies to be liable for conduct of other defendants, other culpable parties. The asbestos bankruptcy trust provisions is basically a way for defendants in the tort system to get a set-off for any claims that people have made in the asbestos bankruptcy trust system. Those claims are also admissible at trial. And so that is a way for defendants to spread out their liability and to say that we're going to try to limit a defendant's liability only to its own conduct. And the bare metal defense has a very similar approach to that, to say that we're not going to hold companies liable for a product made by somebody else is a similar way to deal with that. But I think the corollary of that is that a company is liable for its own product and its own conduct. And so here we have a premises defendant and an insulation contractor who had a lot of culpable conduct in exposing Mr. Beverage to asbestos.
Where is bare metal in this particular statute? In 686B, I just don't see it in there. And so don't I have to go outside this statute to bring that in, and isn't that a problem?
It's correct that the words bare metal don't appear in the statute. Bare metal is kind of lingo, I would say, that attorneys and some courts use in describing this defense. It wouldn't necessarily appear in the statute in order for it to have that meaning. I do think that we have to look outside the statute to determine its meaning, given that it is ambiguous, given that the terms are kind of unusual in talking about third-party products, and the fact that when that's put in context with asbestos litigation nationally and all these other cases, including the DeVries case, you can see that that language has a specific meaning within the context of this kind of case.
I have a couple questions. First, I mean, wouldn't you get the bare metal defense anyway under the common law? If you didn't supply a product that contained asbestos in any way, shape, or form, why would you be liable for asbestos? Most courts have, including the U.S. Supreme Court and Maritime, have found that there is liability under certain circumstances. So if a product, say like a pump or a valve that's used in a system, if the manufacturer supplies its product with an asbestos product, or it knows that an asbestos gasket, for example, will be used with the product, the courts have found that that pump manufacturer is liable for the exposures that are caused by that asbestos product, because there is only exposure in the maintenance and maintenance and repair of that pump. So it is a danger that arises from the manufacturer's own product. Good answer to that question. I have another question. There is some legislative history available on this legislation, and I spent a good part of the one afternoon watching it. And there's a debate between Senator Zahn, who I think was the floor manager of this bill, and Senator Bolton, who's a trial lawyer, an articulate spokesperson for the other side. And it does seem that in debating the legislation, one of the assertions that was made that was really not contested by either side was that this bill was meant to stop what they call double dipping. I have no idea, whether it truly is double dipping, but it was meant to prevent parties from making a claim against these trusts, and then at the same time making a claim against a company that's actively in business, not in a bankruptcy, and merely having to be using asbestos or have a workplace that used asbestos. And if that's the case, doesn't that legislative history tend to support the defendant's interpretation of this bill?
I don't think it does. I definitely get what you're saying, that asbestos bankruptcy trust provisions are meant to, double dipping, it's really a mechanism so that to defendants in the tort system don't bear all the liability when there are multiple culpable parties. And so the statute is saying that on the trust is saying that if a plaintiff receives some compensation from the trust, then defendants in the tort system are going to get a set-off for that, for any monies received in the asbestos bankruptcy tort system. It is not, those provisions really don't have anything to do with who can be sued and who still has liability under the common law.
Vote was on this in either house?
Honor. One thing I also wanted to quickly mention was the consequences of the construction that the Court of Appeal, the District Court and the Court of Appeal, their interpretation is quite extreme in that it completely eliminates longstanding causes of action against premises owners and against product suppliers in asbestos cases. And to interpret the statute to have such a big consequence when the statute doesn't even refer to premises owners or non-manufacturers, this is an indication that is not the most reasonable interpretation of the statute, and that it should be read to avoid an absurd result. And in using that argument about absurdity, I'm really using it as a tool of statutory construction, not saying that it's the literal, that the literal meaning should not be applied. But I think the extreme consequence tells us that that is an absurd interpretation. I can see I'm out of town, so thank you.
Thank you. It's my understanding Mr. Livingston is going first.
Yes, Your Honor. I'll be arguing on behalf of ALCOA and splitting time with Mr. Horan, who will argue for IITI. I think we should go back to first principles in assessing the interpretation of this statute and to determine whether or not it is in fact ambiguous before we overlay the bare metal defense by way of statutory construction, which would be improper unless there's at first an ambiguity. So the statute's a very simple 28-word sentence. It says, and it bears repeating, that a defendant in an asbestos or silica action shall not be liable for exposures from a product or component part made or sold by a third party. You know, I'm not a grammar expert, but I've read and am experienced with the writings of our language, and the way I see this sentence is the defendant is the subject. The defendant is modified by only one phrase. The defendant,
Counsel.
yes.
And that's the tactic that the district court used when it went word by word. This is I can't remember how many words you said, 10 or 13 word sentence, but it was part of an act that included 3 entire chapters. Don't we have to look at the whole entire legislation and the background of that rather than just this one code provision in isolation?
Yes.
Even in determining whether it's ambiguous.
Yes, Your Honor, and I'm prepared to do that. And the way that this statute modifies the subject defendant by referencing as a defendant in an asbestos action, the asbestos action is defined in an earlier act, the 686A subsection, the Bankruptcy Trust Transparency Act. And it's important because the definition of the asbestos action is such that it includes all causes of action from asbestos cases arising from exposure or health effects, and includes all derivative claims. That
And it focuses on, and counsel, but that focuses on the plaintiff's harm. Is that right? That
yes.
Definition?
Yes.
It doesn't focus on the what kind of defendants could be at issue. It focuses on the plaintiff's harm.
It focuses on the type of case that comprises an asbestos action, which is what the plaintiff would bring. And the important part is that it doesn't have any language in there that specifies that it somehow limits the defendant term to a product manufacturer defendant.
I mean, when statutes are written, and particularly when it's kind of in a specialized area, we assume that the legislature, if they're using terms of art, intend the term of art to have the kind of legally accepted meaning. And would you agree that the phrase product or component part made or sold by a third party in the law as a whole is a term of art related to product liability defense and the bare metal defense, as it's colloquially been known or called?
Yes, but we get there only by back-ending the bare metal defense in to establish the appearance of an ambiguity if you read the language itself.
There. If you say, for example, that phrase appears 319 times in the case law, federal and state courts in the country, and every single time it appears, it's in a product liability action, and 198 times it's in an asbestos case, that seems to me that phrase has a particular meaning within the law, not when you look in a dictionary, word by word. So why wouldn't we give it its legal meaning?
The legal meaning to the term defendant as the party being sued in a case. And the fact that there are similarities with the perhaps technical terms of art and products liability cases, the sentence structure.
Spousal support statute, we understand that that means financial support, all right? We don't look at a dictionary and say it could mean emotional support, care, et cetera. It's a legal term of art, we get it. Why would we treat this different?
We should treat this differently because of the way the structure of the sentence is phrased. On the one hand, the term that you're referencing is a modifier, but it's the modifier for the term exposure. It's not a modifier of the term defendant. The defendant, the subject, shall, the verb, shall what, the direct object, not be liable. Not be liable for what? Exposures. Exposures, how's that modified? For product or component by a third party. And I get what you're saying, but I still stand by the position that in order to get there, even if we're looking at the legislature believing what technical terms the court has used, in the way this is phrased, it does not modify the term defendant. It's not susceptible to more than one reasonable interpretation. That's defendants generally. And
Counsel, what of Iowa Code 613.18 and the immunity, the limited immunity that's provided there? Do we consider that the legislature would have been aware of that statute and considered that there was that statute applied broadly? And so when the legislature said a defendant in an asbestos case, were they distinguishing types of product liability actions?
I believe that this defense is written more broadly, and the intent of the legislature is not to have two statutes that act in a similar way. That statute operates differently in that it is not specifically applied to the asbestos arena, and this provision, of course, is in the larger context of a asbestos tort reform bill with the admitted purpose by plaintiff to do tort reform, and that's exactly what it does, is it prevents.
And that's kind of my question, I guess, is if the legislature said a defendant in an asbestos case, could they have been distinguishing the immunity or the lack of liability that they're trying to give to involving third-party manufacturers, and say in asbestos cases, you're never liable for in a products case for the product or component of a third party, whereas under 613.18 it's a much more limited immunity. And so could they be making that distinction?
I presume that they could be, Your Honor. I wouldn't disagree. I would assume that they're intending to make a difference, and that's why it is a separate statute and a new one.
Reading of the statute, then, only manufacturers can be liable for exposure. Is that correct in the state of Iowa?
I believe that the parties that are held without liability are all defendants except those who make or sell.
And that doesn't involve a manufacturer that would avoid the immunity in this statute.
I'm not sure that there would be.
So in your reading of the statute, everyone but manufacturers has immunity from any asbestos claim.
Who's a manufacturer would not be eligible for the removal of liability under the statute.
Can you,
Liability, Your Honor, it establishes the lack of the defense.
All right, so that's a pretty sweeping interpretation. This piece of legislation passed, if I understand it correctly, and I know you'll correct me if I'm wrong, it passed in a month. Tort reform is controversial usually, and it's fought tooth and tongue. Proposals of tort reform are ordinarily papered on the floor, what we call papered. That means, countless amendments. Do we have any of that history here? It seems, and maybe you can tell me what the vote was too, it seems like this passed rather quickly. And that raises at least the question in my mind as to whether this was really seen as a substantial revision of liability or kind of a technical adoption of a bare metal defense. So you understand the general nature of my inquiry, so why don't you help me out, please?
Speculate, Your Honor. I would speculate that the legislature is in a position where a party has a majority and they can get legislation through as they desire, whether they have robust debate that develops the legislative history so that we can later rely on it or not, they're able to pass the legislation. And I see that I have exceeded my time, and I yield to Mr. Horan.
Mr. Horan.
Good afternoon, Madam Chief Justice. May it please the court. I represent Iowa, Illinois Taylor Insulation, a company formed in Iowa in 1963 and has been operating continuously and employing Iowans throughout that time. I would like it to be noted that just as ALCOA is not in the asbestos business, Iowa, Illinois Taylor Insulation, I will refer to them as IITI, are not in the asbestos business either. They are in the contracting business. They're in the construction business. And historically, they have delivered products, equipment, some of which contained asbestos, to their customers at their specification. And that is
Counsel.
pattern here.
And
Yes.
I know you've got the time, so I apologize for interrupting you. But so you say that you're a contractor. Would you consider your client to be a distributor of insulation products?
Yes. Currently, now, we are still a distributor of, I believe, Johns Manville and some other manufacturers' products at the relevant time. Sorry.
And so are you taking the position as well that only manufacturers are liable under this provision, that distributors are not liable as well?
I am, Your Honor. And I think one of the questions that was fielded by Ms. Shirley earlier is if we're going to look to the wider if we're going to go outside the 28 words of this subsection, we need look no further than the titles of 686A, 686B, and 686C. Those three chapters were part of a greater tort reform movement or legislation, and the titles of those acts deal with bankruptcy, transparency, asbestos and silica priorities in 686B, and in 686C, we get to successor liabilities. And I think that instructs us in what the legislative intent was. Now, I'm not conceding that we even get to the principles of statutory construction because I don't think the terms are ambiguous, but assuming arguendo that we do, it's fair to say, and it's rational for the Iowa legislature to make that their legislative intent, to protect Iowa small businesses that have continued to operate and employ Iowans when the manufacturers of asbestos, the miners, the manufacturers, the makers of asbestos products, such as John Mansfield, sought bankruptcy protection and are now insolvent. I would note for the record that the first asbestos claims filed against Iowa, Illinois Taylor occurred in the 1990s, after Johns Manville sought the bankruptcy protection.
Some of the question we've had, why isn't your client responsible for a product, it says not liable for exposures from a product or component part made or sold by a third party. Why isn't your client an entity that sold a product that contains asbestos. Why isn't that enough to exclude your client from the benefits of this immunity?
Because I think if you go to the language of those 28 words, if you look at them, they're solely resting the liability on manufacturers. And as Ms. Shirley noted, some of the interpretations at the lower courts deal with miners and millers of asbestos. And in that context, I think the legislation is clear in the three parts, 686A, B, and C, that the priority of the legislature was to fix liability properly with those manufacturers, millers, miners.
We keep talking about the plain language of the statute. It's unambiguous. If the legislature's intent was to say no one other than manufacturers shall be liable in an asbestos action, that seems much easier than incorporating a term of art that's used only in asbestos cases related to product liability, bare metal defense. So shouldn't that counsel against the obvious reading or interpretation that you want when it could be done so clearly?
Well, to the first part of your question, Your Honor, I agree. It could have been done. Unfortunately, the legislature did not do that. I can't speculate as to what their thought process was. I also would, with which to
Don't you lose on it? It says made or sold, and made would be the manufacturer, sold would be a seller anywhere in the chain of distribution, I would think, including a distributor, right?
Your point, and at the relevant time here, we are a distributor, but the business of IITI is contracting. And so what they're doing is, at that time, you couldn't just go to Johns Manville and buy the type of product that ALCOA would have needed to make aluminum. So that's where we are, Your Honor. We are a distributor. And further to your point, Your Honor, and this goes to Ms. Shirley's absurdity argument, I think it would be absurd if we're going to go down that analysis to fix liability onto IITI, as you say, for being a distributor and installer of a product and tag them with the moniker of seller, but allow, say, pump and valve manufacturers who deliver a bare metal product but require an asbestos-containing component part for that piece of equipment to work, for them to escape liability. What this legislation does is fix that liability where it properly belongs, and that is with, unfortunately, insolvent companies. One final point is that one of the issues raised in the briefing, but which wasn't preserved and which was conceded by the petitioners here, is that this legislation, if applied, as applied, would deprive the plaintiffs of a remedy. And I can't disagree with that strongly enough. The legislation provides a remedy, and it is the bankruptcy trust system. One of the inaccuracies presented by Ms. Shirley moments ago was that the trust system was set up to provide defendants with a set-off at trial. And I would just note for the record that the bankruptcy trust system was provided for plaintiffs to recover for injuries caused by manufacturers of asbestos-containing products. I've exceeded my time. Thank you very much.
Ms. Shirley.
Thank you. So just one quick clarification. I don't think I misspoke, but if I left the impression that asbestos bankruptcy trusts were for the defendants, obviously it's a system by which a plaintiff makes a claim to that trust. And Johns Manville is, I believe the first trust that was ever established, and still is a going trust right now. But the bankruptcy tort system the bankruptcy claim system, that's pennies on the dollar. These are extremely serious injuries. Mr. Beverage died of a terrible cancer, and the asbestos bankruptcy trust, he did have a few claims that he made in this case, and all of his claims together were less than $100,000 in payments. It's quite a small amount of money compared to the damages that he and his family have suffered. And so along that line, I want to talk about the culpability of the companies that we sued here, and sort of bring this a little bit to some of the consequences of the statute, Mr. Beverage's exposures occurred decades ago, and that's a very common, exposure history in these cases. But what would happen if the lower court's interpretation is affirmed is that even today, if ALCOA wanted to remove asbestos insulation from its property, it could do so without any kind of precautions or protections for the people that are visiting on the property. I think they would still have to protect their workers, I hope, under OSHA provisions. But to say that the premises owner would not have any kind of duty to protect its visitors is really an extreme thing. And again, is something that we don't expect to happen with little debate and little explanation and with kind of this esoteric term of art language. And in terms of interpreting the statute, when it has such an extreme result, that is one thing that the court, can and I think should consider. The reason I'm saying that about the ALCOA property is because, and this is in our briefing, but the plant still has asbestos insulation on the property, and that's in the record at 346. The abatement surveys done. Yes.
TI claim relating to their use of the product or their sale of it?
Both, Your Honor.
The sale of it or the distribution of it, as they say.
IITI, they sold the insulation to ALCOA to be installed on the property. They also did the actual installation work themselves, which means that the dust that was created that exposed Mr. Beverage, that was created by IITI and their conduct and their work activities on the property.
Similar claim against ALCOA?
Yes, Your Honor. I don't believe they did manufacture.
I mean, I know you think they're both liable, but isn't there maybe a difference between the two of them? Because the IITI, they, product or component part made or sold by a third party, you're suing them for a product they sold, not that a third party sold. That seems to me, that's a little different. ALCOA didn't make or sell any asbestos containing products. They just provided a work site where there was asbestos. So isn't there maybe a difference between the defendants under the language of the statute?
I agree with you. There is one. I still think, I think even...
What would be the purpose of that then? To allow the company that sells the asbestos, installs the asbestos, to be liable, but then the company that purchases it and uses it in the plant for whatever reason to not be liable. It seems like it would be one, either it's a bare metal defense or it covers both, but I'm not sure why they would carve out liability for sales but not users. That doesn't.
I agree with you. I don't think that makes a lot of sense, but...
Couldn't it be that one is making money off it and one isn't? If I'm selling a product and manufacturing it, I'm presumably making money off it. But if I'm just purchasing it and using it, I'm not making money off that particular product.
I guess that is one distinction that you could make.
But counsel, isn't the claim against ALCOA's premises liability though? It's you invited people onto your property. It can't apply to your employees because they're subject to workers' compensation. But when you invite independent contractors, then you have to keep them safe, and you didn't keep them safe because you allowed the asbestos insulation to not be protected and to people to be working that. Isn't that the premises claim that's related to ALCOA here?
Yes, Your Honor, that's exactly right. That's exactly our premises claim.
If you looked at some of the other, so 686B.3 is the provision that kind of talks about this whole process that non-malignant plaintiffs have to go through. And one of the provisions is that they have to give details about the products and their prior employers. And there's a provision, subsection 4, that actually says that if the plaintiff does not identify a specific defendant's product or premises, then that defendant is dismissed without prejudice until the plaintiff can specifically identify that defendant's, and the statute says product or premises. Does that support your idea that the legislature did expect there to be a premises liability claim?
Your Honor, I do think it does support that. It's a common law. Premises liability is common law, but also that statute, you're right, it seems to expect that those claims would continue. And there's nothing in this statute that would specifically say that that is going to be abrogated.
You may wrap up.
Thank you very much. If there are no more questions, I will end my argument. Thank you.
Thank you. The case of Beverage versus ALCOA is hereby submitted. Next case is in re Marriage of Hutchinson.